This session
Mm,
is brought to you by our generous sponsor, Delegate Legal. Thank you so much. And now I'm very happy to introduce our speakers, Ainslee Schreiber and Carlos
mm,
Cucurella. Ainslee is the head of IP at WeWork, where she leads the team responsible for global trademark, patent, copyright, trade secret, and
mm,
advertising matters. Prior to joining WeWork, Ainslee led the IP team at Starwood Hotels and Resorts and was
mm,
former counsel trademarks at Altria.
mm,
Ainslee is the chair of Trademarks and Unfair Competition Committee at the New York City Bar Association and currently serves on the board of directors of INTA. She has an MIP and
mm,
JD from the University of New Hampshire School of Law. Carlos focuses on international IP and brand protection. He manages worldwide trademark portfolios and advises clients on international trademark
mm.
clearance, registration, licensing, anti-counterfeiting, policing, and enforcement. Fluent in Catalan, Spanish, and French, and admitted to practice in Spain, Carlos has extensive experience in European Union intellectual property law, as well as trademark practice in Latin America and Asia, especially in China. Thanks for joining us, both of you. I'm going to kick off with the slides and pass it right over to you guys. I'll pop back in with that CLE code soon. Thanks so much.
Well, thank you so much. It is such a pleasure to be here. Thanks for your invitation. So we're going to be speaking about at home and abroad, building and protecting a strong international brand. It's great to be here, and it's an even greater pleasure to share this panel with one of the leaders in our field, Ainslee Schreiber. Ainslee started, as you've heard, her in-house career at Altria, the food and tobacco conglomerate, a number of years ago. And in 2005, she was hired to create Starwood's global intellectual property team, where she oversaw, and correct me if I'm wrong, Ainslee, but more than 20,000 trademark conflicts and application and records for well-known marks such as Sheraton and Westin and St. Regis. She also oversaw the incorporation into the group of marks like Le Méridien, and also launched such well-known brands as W Hotels or Element. And she's now at WeWork, where she leads the global IP team and where she oversees, again, thousands of trademarks around the world for WeWork and also the We Company. Ainslee, it's great to have you here. And I guess my first question to you is, how many brands do you think you've launched during your career?
Well, great to be here. Thank you, Carlos, for the very kind introduction. And just in thinking about this question, I was recently asked by someone else, and when I sat down and counted, I think it was like 230 something brands I could remember, mostly in the services industry, and a lot of restaurant brands actually, but and some retail, but some were global, some were regional, some short-lived, and some are still with us today. So I think it was, last time I checked, it was a little over 200.
Wow. And what do you consider a successful brand launch?
I mean, ultimately, it's that the client, our internal business clients, the company can use the new brand without issue, that no one's threatening or trying to stop them from using it. You don't receive any cease and desist letters, any injunctions, that hopefully will be, from your clearance. You'll have done a clearance so you can understand the issues, but that's really a success that, launches without issue, no PR issues, and the business can go on.
So no issues to the brand, no issues to the business or to your team. And how do you get your team involved in the process? And who do you get involved? Is it only your legal team? Is it the corporate folks, the marketing folks, PR people, your regional offices around the world? Tell us a little bit about how do you get your team involved to ensure a successful launch?
So, I think if you're thinking of the direct IP team, really important to have them part of the process with the clients and understand that the launch of the brand successfully is part their success. Everyone in legal and in the IP team should feel responsible for that successful launch. I also think to review the search results with them, if there are professionals who are responsible for prosecuting those brands, they should have a say in that. It shouldn't be just the lawyers who are making those decisions and recommendations, because if it's a hard brand to get registered, they will be responsible for it. And everyone knows that you want to make your paraprofessionals happy. And I think if you're thinking of the business team, excuse me, I think absolutely it includes folks from your IP team, but it also includes folks that will also have a part in the success of the brand. And if there should be an issue happening, they're going to be involved. So that may be your PR folks, if a cease and desist happens, anything, they should be included. Get them on your side as much as possible. They should be involved in those decisions. People like your head of litigation, even if you run all the IP litigation, they should know, they should be aware. Your brand and marketing folks, I think your regional counterparts should know, whether it is helping develop a good translated or transliterated version of the brand, or just because if there are issues that pop up in a region, they may hear about them first. So even your regional counsel, also very important to have them involved. It really should be a true cross-functional team.
And you said that, of course, you need to work with your legal team and with your outside counsel. They are, they know the technical aspects of the law, but how important is it that they also know the industry and understand it well? Because at least in my experience as outside counsel, when you're doing a global launch, when you're trying to clear a mark regionally or globally, yes, you identify specific references, but you want to understand the industry and the context to be able to give a meaningful and practical advice, regarding whether something particular is risky or not. So, how important is it that you and your team and your outside counsel know the specific industry you operate in? Hotels, tobacco, co-working, startups.
Yeah, I think it's critical. I think it's critical to help building a strong global brand, to know the industry, to know what, in the IP world, a trademark specifically, we have classifications, everyone knows like S25, 35, 45. I think it's knowing what categories, what classifications you're immediately going into, but also what you can see yourselves going into a year or 5-10 years down the line. You want to be able to file in the first in that jurisdiction for those categories. So if you're in a real estate based business, like I've been for 15 years, I'm going to want to secure, class 36 for real estate, but also, now class 35 for co-working. There's a few categories you want to be able to go into. I also think some industries are more aggressive than others, so you want to be mindful of that, what the competition is. And
some are very heavily regulated, and in those industries, the appetite for risk taking may not be very high, and you need to be a lot more cautious with your calls.
Absolutely.
Like
and also know what countries are important to you. Where in real estate, where you're going to develop and where it may not be as critical to go into.
They're important now, and are going to be important in the future for your developers or countries that may emerge a few years from now. So you need to start doing your work, your clearance and filing work ahead of time.
Exactly, and also knowing what countries may gravitate towards certain brands. There are certain countries that liked Le Méridien and would infringe on Le Méridien all the time, and some Sheraton. And it's just whether it's how that brand resonates with the culture there, or whether it was a famous brand there. I think that's part of it. When you really want a global brand, to understand that each culture, each country may view the brand differently, and you may have some hotspots to defend.
Mm-hmm. So and now you've gotten this call that, look, there's a new product you need to launch. There's a new hotel brand you need to launch. There's a new specific aspect of the co-working experience or of the hotel experience that you want to specifically and separately brand, and you need to call your team, get together, and design a global search strategy. So what are the general timelines here for a global launch?
So, in a perfect world, I would love 10 months, but that perfect world
that doesn't happen. 10 months doesn't happen.
I think actually now 3 to 4 months for a very big brand, at least in the industries I've been in, have been the norm, that 3 to 4 month period. Lately, I'm seeing folks, my colleagues who have mentioned to me, sometimes folks want 2 to 4 weeks, not to launch a big brand, but at least something that is certainly more material than a slogan you're going to use for a week or two. Mm-hmm. Because in the online world, they want to move fast. So I would probably make sure within a 30-day period, 2 weeks to 30 days, I was able to articulate what that timeline would be, what we're going to do in 2 days, 2 weeks, and 1 month. I try to have that educated to clients as much as possible. So it may be that I want to do a knockoff, which is maybe a Google search, maybe USPTO, or maybe it's a WIPO search. Do that within 48 to 72 hours. And then if no immediate results happen, then maybe I will have a WISP search or something similar to that, where it's a more global footprint that I'm looking at. And then if it's a brand that is going to have a significant amount of money put towards it, or return on investment, a lot of times in real estate, you have a property being built that it's millions upon millions of dollars. You want to make sure you secure that brand. For that, I will do a country level search. So I will go in and I will go directly or through wonderful counsel like you, Carlos, and say, hey, could you please do a diligence in this country, just to make sure I'm really seeing everything and can guide the client. I think the amount of money, the amount of revenue that you're putting into something also may dictate that timeline and how deep you need to go into the diligence.
I feel in my experience, some clients are very sophisticated, others a little less because they're not trademark lawyers like we are, but they don't have a good sense of the timing, the amount of work and effort that goes into something like this. So have you done work to educate your internal clients about the timeline for launch? Have you come up, for example, with templates or with a template that they need to follow to make sure they give you the information you need, and they have a good sense of timing when they engage in a launch of this nature? Yep,
I'll generally communicate it in a deck. I believe in decks for clients. Every in-house counsel has their own style, but just to give them advance notice that it takes this amount of time. So when you develop your work back plan, and just a work back plan would be, if they want to launch in December 1st, you're going to need to give this to me by October 1st. Something like that. So from the date they want to launch, it's working back given my timeline in mind. I will do that. I will also say to them, start with a healthy number. Folks may only want one brand and one brand only. And that may not be available. I think it is very auspicious, an auspicious goal to have one brand and it be one brand only. So I'll generally tell them even 10 to 20 names at first. Some won't want that. I've had some in the past give me over 100 names to search, which that's not productive either. But tend to think 10, 20 is great. And then as we do a knockout and as we go into it, we can narrow it down to maybe the top 3 names that they want. I also tell them that of all those names, you should be satisfied if any one of them launch, because again, if you're just giving me names and you're still going to fight for one that is too expensive or time consuming to get, it's not worth it. Come up with a list.
It's always, for some reason, it's always that they really like, of the 20 names, the one that perhaps doesn't look best, right? It happens more often than not.
Yep. It's like the universe sends a message to them saying it's only, one name and one name only.
Yeah. And when do you decide not to do a comprehensive search like the 3 levels that you've discussed here, and just try to do like a quick knockout just for use? What factors do you look into before deciding how thorough you want to be with your searches?
Definitely the time frame. So if somebody is doing a one-day event and it will not have much of an imprint in online presence, or if it's not going to happen again and again and again, a reoccurring brand, I wouldn't put that much time, money, and effort into the clearance. If it's something that could be easily changed. So if it's something that is strictly internal, or if it's something that is only going to be a slogan somebody uses for a couple of weeks and it's not going to be expensive to flip to another, I won't devote that much time. And it's because, if you have a prolific marketing team or brand team, which hopefully everyone has, they come up with a lot of creative marketing, and you can be searching and clearing all day, every day. And a lot of times you just don't have the resources for that, or frankly, just don't want to devote that much time to just clearing. There are other things you should be doing, hopefully.
So now you've come up with a strategy, you've done the searching you're supposed to do, and let's say we're dealing with an important brand that you need to register, and then you obviously not every brand is available everywhere. When you're dealing with global searches, you have 100+ countries out there, so it's impossible to expect that a single brand will be available everywhere. So inevitably there's issues. There's going to be issues here, there. There's going to be significant problems in certain countries, not others. Once you have a good sense of what the issues are there, and you identify the risks and the potential problems, how do you go about dealing with those obstacles? And I understand that each country will be different. Each reference, each potential obstacle will be different. It needs to be evaluated on its own facts. But what is what are some of the issues that you follow to address those risks, those potential problems?
Sure. Well, I think sometimes there are significant issues, and sometimes the issues are more, I would say, in the practice of what we do. So I frankly think to have a consistent global brand that will be a strong brand, you have to make it as universal as possible. So if you have a name that seems fine in 80 to 90% of the jurisdictions you want to go into, that to me is a good result. If you have something that is more problematic, maybe you have to revisit that brand, but you should be, based upon your clearance, going out with something that is strong for that consistent brand experience. I generally would create a filing program on that, so that there were the countries where I really divide everything in green, yellow, red. I know a lot of folks do. And green would be found no immediate obstacles in that jurisdiction, should be good to register and use. Yellow to me is more of, again, that what I'd call that internal issue that you face. And it may be there are problems to registration that aren't really meaningful. So just somebody has an old registration and you really need to assess how much problem you're going to have to get past that. But it's not any threat to your use of it. And then red is, oh, somebody already has that brand in a country, don't go in, or we really need to revisit it. And based upon those buckets, I create a filing program. And that filing program really is based on the clearance results. And that will dictate how I go into a jurisdiction. It could be that the green is, this is the word mark, we go with a robust set of services. Yellow is, we really have to tailor this. Maybe we go in with a logo. Maybe we go in with a color of it, or modify the logo somewhat. And then we go in with tailored services that we think will overcome any objections either by the trademark office in that jurisdiction or unnecessary objections from a third party that really aren't in our space. So we really do create that building that strong brand based upon search results.
And the red, the no, when you know that this is a no, how do you deliver this bad news to a client? Because clients usually don't like to hear that, so it's a red. How do you deliver those news, and when is a red a real red?
So I usually don't like to phrase it as a no. That's why I'm grateful for the red color, because it's not an official no. It's let's talk about it. And, I think when you explain, well, these are the risks, this could happen, generally the business aligns with you and they want a successful launch just like you do. And so I will certainly look to creative solutions within the business, within my own team, and with local counsel and outside counsel, international outside counsel, to think, hey, how much of a risk is this? And then, I think if people feel empowered, that they're part of the decision-making process, they either move away from the risk or they create creative solutions to get past it and to mitigate the risk. So, I mean, my recommendation is to really empower your clients to be part of the solution and be part of the decision making.
And let's think about some of those solutions or specific, options or strategies that you use to address specific complicated, problems. And I guess the first question is, you need, when we encounter potential risk, you need to investigate it, right? So you need to conduct an investigation. And then based on that, one of the options that you could look into is to try to seek coexistence or a consent. Do you like that route? Do you typically try to stand away from consents because it's easy to say no, or what's your approach?
So maybe just to talk a little bit about the premise of the question, doing investigations. I think folks who have worked with me, and Carlos, I am big on investigate, because especially if you're in an organization where it's big, it's global, sometimes you don't know what the local folks may have done in their zest to get something happening on the ground. And it could be someone in your own organization that has either filed before you or has done something, right? Then I think it's important, if you're in a licensed model business where you're licensing your brand to third parties, that you also make sure it's not your partner locally who has done something, because you really don't want to, take any action against someone you're going into business with. And then the first thing when it's a consent, once you realize it's not somebody who's your partner and you have the opportunity for consent, I'm not a huge fan of consents, because I think, again, to create that strong international brand, you want the registry as clean as possible to enforce it against third parties who may encroach on your space. So I find I haven't asked for it often if it's a brand that I find to be super important, like a core brand to your organization. If it's something that's short-lived, absolutely, that we still need a registration for whatever reason. But I also really don't turn away anyone from asking for a consent. So if I find somebody in the brand community is asking for a consent, I generally give it, unless, again, it is that core brand, something that is critical to the company's success, then I tend not to give it either. But when all else fails, I try to be as amicable as possible. I think it creates a good brand community.
Sure. How about acquiring rights, acquiring registrations when that are going to plug in a given country? What's your approach to that? Have you often tried to recapture marks in this manner, in a country where that you're not going to get through, and that there's a clear obstacle that you will not be able to overcome in any other way?
Yeah, I definitely think most folks have tried to acquire a brand, maybe a third-party, registration or application that predates you. And generally, the hope is that they no longer have interest in it, and it's just something on the registry that you can acquire just to avoid any technical issues. So I generally would advocate for that, including to do it anonymous. So a lot of people do it anonymously. I've done both anonymously and where I was open. I tend to, if it's done anonymously, share that it's being done on behalf of a third party so that folks know, somebody else will eventually acquire it. But I think it's a great way to acquire some, frankly, no pun intended, some real estate in the trademark space, to go out and basically get a deal to get that brand.
And how often do you move to cancel marks that you investigate and know that are not in use? And do you ever do you also file these kind of actions on an anonymous basis in places where that's a possibility? Because that's something those are strategies that we have, used in the past.
Yep. I think I generally, if I see that the mark has not been in use before I'll file a non-use, I will ask to acquire, just because it's a nicer way to do it versus, filing an action against somebody, and try to, again, have a deal. If I can't get a hold of anybody and I have no record of any use, then that's when I file the non-use. And I tell my client this could be resolved in years. Through acquisition, it's just the cleanest way of doing it. So you can present it to your business team. Oh, look, these rights are secured, but, non-use cancellation, I would absolutely do it if I can't get a response. It just takes a while. So it's not a clean resolution before the launch of a brand.
Good. So are there any countries out there that you view as particularly challenging or complicated, or they're all the same?
So I love all jurisdictions. I find no jurisdiction any more challenging than the other. There are just things that really you have to watch out for and know how that country practices in the area of trademarks. The US and Canada, they have common law use. So to look and see if there are any pockets where someone could own it or claim to own it, especially if you want that consistent, strong brand across a region. I will say that, also the European Union, there is the EUTM, but there's also national registries. And if you want to do something throughout the EU, you always have to make sure that national jurisdictions are checked as well. Someone could be very famous in Spain, but not in the other countries. And so just to double check on that. Sorry, go ahead.
No, sorry. Talking about the EU, I think it's increasingly hard to clear names over there, just because so many marks are coexisting and there's no citation practice. So the registries are clogged with marks that are sort of similar to each other, and that make it really hard to comprehensively clear a mark across the EU. But go ahead. I interrupted you.
No, and then you'll have maybe Latin America and China and Asia, where there are so many countries to clear, and they all have different systems, and it's just making sure you have a cohesive approach to that, and talking to your business, because nobody really wants a patchwork quilt of a brand. You want to make sure you can successfully launch in all those countries, and so that would be part of my analysis, just to say, listen, while nothing is too problematic, there's 50 different jurisdictions individually you have to make sure you are available in if you want to go into Latin America and Asia.
And now you touched on China so briefly, because China tends to have a lot of volume, and there's, in my experience, quite a bit of piracy. One of the strategies that clients have decided to adopt when it comes to launching a business in China is whether to adopt a trademark in Chinese characters, to come up with a version, with the Chinese version of their mark. Is this something that you have encountered too? Is this something that you have pursued before, and how helpful has it been?
Yeah, I did not fully appreciate the need to have a local version frankly, China isn't the only one. It was Russia with Cyrillic, Arabic. Anytime you have non-Roman letters as your brand, I think it's important. And I didn't fully appreciate it until I was relocated to China. We could have a global brand, but it also has to appeal to the local market. And in a lot of cultures, in a lot of countries, there's translation mandates so that the local market has a full understanding of the brand and the services you're offering. And, I think with China, a lot of us have had infringements there. And for a while, I was dealing with counterfeit properties, real estate properties over there. But they have a lot of fairly sophisticated approaches to enforcement. You can even go to the local provinces and sometimes the local cities, and they have forums for trademark disputes. It doesn't always have to be the courts. They will have local officials decide trademark cases, and that's all they do, and they're very adept at them. And I think in one case, I had a raid against a counterfeit hotel, and there were 40,000 pieces of branded items confiscated. So I actually—
And when you say a counterfeit hotel, you're saying, say, just using an example, a Sheraton hotel that looked just like a Sheraton, that you would walk in, you're like, oh, you're at a Sheraton, but it had nothing to do with the Sheraton or the Marriott Starwood groups. That's a kind of counterfeiting that we're dealing with, in the hotel service industry.
That's right. In the service, WeWork has them as well. It's not just China; it's in many other jurisdictions. I sort of think it's an indication that you have a strong brand when someone does that. So it's catch-22 at times, but I think it's nothing different from what Apple's experienced with their stores. A lot of luxury retailers have storefront counterfeits out there.
Yep.
To me, it's the same thing. You sometimes think you are in one of those branded establishments, and you have to double check. Some of them are very sophisticated.
Sure. Now let's just gears quickly. You're clearing, and how important when you're searching a mark, how important is it? Of course, you look at the trademark, you look at whether the mark is available or not. How important is it? Social media, and I know you're going to say, of course, it is important, but how so? And how do you approach, social media and social media handles when you're clearing a global name on a global basis?
I think if you're in almost any modern brand company now, social media is a driving force in your marketing. Mm-hmm. And I've noticed social media handles and really are driving the brand. It's probably the first thing I look at, and I will even do my own research on my trusted phone myself to see, does somebody have a similar name as a social media handle? I think what is also important for folks to understand is when those characters are shortened, because each media handle has a cap on characters, that taking away vowels, taking away consonants, it's going to have a public perception of that brand name. So it really does have to match and mirror appropriately. So I think social media and domain names as well, if you can get a good domain name, if you're in an industry, and this is where you really have to know your industry, if your sales are online, I think your domain names and your social media handles, that's the first thing I look at before I even go into the trademark records, to tell you the truth. Because if we don't have a plan for that, it's really going to change the name you ultimately pick or the business ultimately picks.
And for domain names, questions that we often encounter from clients is, look, we have a domain name, or we were able to find a .com or .org, but we're global. We're launching the brand globally. Should we be acquiring, specific country names and go, acquire the .cn domain name, a .eu domain name, .ca domain name? What's your approach to that?
I think you need to connect with your digital marketing folks, but you have to come up with a budget. And then I also think it's good to acquire those names with redirects, because anytime you are directing traffic to your site, that's a good thing. It may be that your company prefers to purchase keywords, branded keywords or generic keywords. As long as it goes to your ultimate domain name, I think any time you could drive traffic to that is great. I think the more domain names you can acquire will ultimately generate the natural search results that you want when people Google search or other internet search over a brand or an industry, searching for, let's say, co-working space that's available. So I think you should absolutely have a plan with your digital marketing team within a budget. And I find that having those domains a really great way to get use of your brand in a country as well. If you can turn on a .eu, a .es, anything like that, I think it's great to prove use if you also need that, and if you're targeting those customers.
So using that as a piece of evidence to show that you're actually using the mark and targeting, your brand into a specific country. That's interesting, especially for, in the service industry, where sometimes it's hard to come up with good evidence. With products, you have your invoices, you have the actual product, traveling across borders, but you often don't have that for services. So that's very interesting. So now we've sort of, developed, we've searched, we know where the issues are, and assume that this is an very important mark for the group, and that you need to register it for whatever reasons. What guides you to the decision to actually register a name as opposed to just use it without a registration?
There are a few reasons. One, again, it's how long is it good for? How long do they plan on using it? What's your ROI? How much money are you investing in the brand? If you are in a license model where you have obligations, indemnifications to a licensee, all these are important to get a registration if you want to enforce it, if you care that no one else in your industry is using it. If it is not a key driver to the product or the business line, maybe that's something that you don't explore. Just because it's a name doesn't make it a strong brand. And consider the resources you put there. But otherwise, I would assume if they want a clearance of it, they're going to care enough generally to protect it. So sometimes I will say, well, until and let's face it, a lot of clients beta test things, right? So you don't know if it's going to be successful or not.
Right.
So
right.
I'll create a filing program, and sometimes I do it very overtly, in the US, and then see if it's going to expand globally and file by Paris Convention, so I can get that early filing date of when I filed in the US. Sometimes if it's very strategic that we keep it quiet so we control the narrative of that brand launch, I file in countries where those filings aren't public, like Trinidad, Tobago, or there are certain jurisdictions where they're part of Paris Convention, but they are not public and easily disclosed. And
you can keep those filings, away, non-public, and away from competitors or other third parties or pirates that may learn about it and rush to register and get ahead of you and create a headache for the launch.
It's basically you controlling the narrative of that brand launch before the press does.
And what's your general, overreaching strategy, when you file trademark applications? Like, assume that this is like an important launch, where you need, say, a new co-working space, a new hotel brand that requires registration across, multiple countries. What's your approach, and do you tailor those filings to the results of those searches?
I do. I think it's really good to operationalize your brand filings as much as possible. So have a set view of this is the mark I'm going into for these specific goods and services. I will even classify the listing of services. It could be preferred, robust, defined, where maybe it's I just go in for co-working services, or maybe I go in for the full listing of real estate services. So I will absolutely do that to make sure that that internally the team knows exactly what they're doing, and the strategy is a universal approach, meaning if they know I say go in with this logo, like logo version B for preferred services, they generally know why we're doing it. So everyone's comfortable with that approach. And that way you have a global brand that is really fast to launch. So, and that's really just taking the time to sort of take all the details of the clearance and narrow it down to, targeted filings.
And in places where the searches have identified multiple or potential serious problems, do you, if budget permitting, do you file a battery of different applications, different variants of a mark with a logo, with a descriptive term, with a synonym, inverted versions of the logo, in the hope that something will get through? Because as we know, examination practices across the globe are not always as consistent and predictable as we hope they would be.
Yeah, I remember when I was in private practice and I filed an application, I would wait for an office action, and it had a likelihood of confusion, refusal. That was the only thing I cared about. Everything else I think was fine. I'm sure a lot of folks who practice in the US agree with me. I think that, when we want to, when the brand wants to launch some, what I would call more difficult brands, ones that may be a little more descriptive or, non-distinctive for those of us who do work outside of the US, really, really important to see what can go through in a jurisdiction. So I think the US approach is generally, let's go for block letters and go for the broadest. And sometimes your client just wants to use it. And maybe they just want to use the label. Maybe it's just they want to use that packaging, and file for the label, file for the packaging, file for a very stylized logo. And granted, that may not be the broadest rights at the beginning, but it'll make them be able to use that brand, that mark.
Sure.
And then I definitely do file more than one. I think sometimes it's the theory of numbers. You know, somebody is going to receive, you're not always guaranteed the same examiner in any jurisdiction. So someone may receive that filing in a better way than another examiner may. So sometimes more is more.
Sure, and let's talk quickly about the Madrid Protocol, because it's, I think, a key tool when it comes to launching brands on a global scale. Some people, use it very often. Others, not so much either, because they are not familiar with it and don't feel comfortable, or because they are, concerned about the potential disadvantages of the protocol. So what's your view on the Madrid Protocol? And how often do you use it?
I'm a big fan. I think I've filed with people I've worked with thousands of applications via Madrid Protocol. Back at my in-house in-house position, I was young and eager, and I was tasked with learning the Madrid Protocol back and forth and upside down. So maybe I think that's why I actually really enjoy it. I think it's a great way, if you have clients pressuring you or anyone else pressuring you, what's the status of this? What's the status of this? Sometimes they ask me that all day for things. You can learn that in real time what the status of those Madrid filings are when you go online to the database. So that is helpful. You don't have to go to outside counsel and to local counsel. You just get it right on your screen, and that is very comforting. I also think it's wonderful. Sorry, go ahead, Carlos.
No, go ahead. Go ahead. Sorry.
I also think it's wonderful to file in multiple jurisdictions immediately. And it's another way that if you can layer the approach, so you file Madrid Protocol and also file a national, depends on what your budget is, but for jurisdictions that are very important for you, if you take that multiple filing approach, I think it's very helpful to use both systems.
Sure, and one of the main advantages is obviously cost savings, because you can end up saving quite a bit of money, in initial filing costs by using the Madrid Protocol. And I'm sure that budget is an issue for everybody. Now, there's some disadvantages to the system, and some people are reluctant to use it, because of central attack. If something happens to your home country registration, as you know, within the first 5 years of the IR, the entire filing program can be invalidated. You can convert later, but some people don't want that. Or some people, another disadvantage, as you know, is you cannot get very broad, filings with the Madrid Protocol, because you cannot go any broader than your home country application. And for U.S. companies, you usually rely on your U.S. filings to get on a file, and usually those can be narrow, or at least narrower than you could have gotten otherwise going the national route. Does that, affect your whether to use the Madrid or not, or do you strategically just pick up the cases where you're like, I'm not going to go that route here because I know that my home country is potentially at risk because X, Y, and Z?
Well, I think if you have to do a brand launch and you really have to do it in a very short time frame, and you just need something on file, I think Madrid is still the best way to go. I also think if you have a difficult brand that you're not going to have a huge statement of services attached to it, that's a great and efficient way to do it. But I think it's really just all of us in-house, we have a budget to work in, and to do a global launch, it just seems, in my experience, that this is a great cost-effective way to launch a brand while it's being beta tested.
Mm-hmm.
You generally can you don't have to use the Paris Convention if you don't want to. They all can be filed around the same time. So it's great.
And, talking about Madrid, again, just because there's some people who have very different views on whether the system is good or not. There's potentially lots of technical issues that can come up along the way, like procedural issues of, communications between the US, the trademark office of the home country and WIPO, and then, the communications with the trademark offices around the world. It creates sometimes some bureaucratic or procedural complicated technical issues that may eventually wipe out any initial savings that you may have gotten. So is, again, something that plays into your decision to use it or not. I guess you're a pro at it, and you have the right people to deal with those issues. But they do come up. They do come up,
and that's why I have outside counsel like you, Carlos, who are the folks who receive the notification. I think a lot of it is that we don't get the notification in time, and maybe it's past a deadline. Just these things happen. But I have to say, I don't have that many war stories on that. And if I don't have many war stories on it, I think the system works.
Good time. Yeah. Well, just recently, this past month, I had a situation where I had filed an IR to China, which was the subject of a non-use cancellation action by a third party. And I learned that the Chinese trademark office has no obligation to notify you of the non-use action or to even tell WIPO. So I was the agent of record of the IR, and they just sent me by mail the notification in Chinese. And luckily, in the middle of the pandemic. So luckily we had someone in the office to receive the notice, all in Chinese. And I had time to deal with our trusted Chinese, counsel to respond, but it did create issues. And sometimes, not always, for the most part, it works well, but, often, the trademark offices don't talk to each other, or they don't always follow clear guidelines as to what goes where or who notifies what. But anyway, I do love the Madrid protocol too, and we use it all the time, more and more and more. And just wanted to get your thoughts.
And, I do think things happen. Listen, you could have a Paris Convention
claim
priority that doesn't. Things happen, and I think we're tasked with creating solutions. And I also think it's great when you can work with your outside counsel to have those meaningful conversations of, listen, what are the issues that I could be facing, and how do we deal with it? So I think when you have the protocols in place, it's a good thing to have those different options, especially in your budget, and especially when you're doing a global brand.
Talking budget, because budget is always an issue. Obviously, these launches are expensive. Searching, filing, maintaining costs money. So how do you manage a budget for a global launch, both internally and as you interact with your outside counsel or with your network of foreign associates around the world?
I mean, I definitely think you have to tell your clients and tell your finance team, this is the budget. And you work with outside counsel to discuss that. It's also important to have a range and what that range includes and doesn't include. So if there is, for example, if at the last minute, someone has 10 new jurisdictions they want to go into that weren't included in the original request, that has to be included. You have to say that is outside the scope and more money could be needed. I think it's also important that if you tell your business client, hey, this jurisdiction may have a significant risk to it or any risk at all, to talk about how much you're going to invest in that jurisdiction before it isn't meaningful anymore. If it's a $20,000 brand launch, and the risk could be $1 million. And, you just have to have that sort of return on investment discussion with your finance and business folks. But I think communicating that budget and also making sure you're on top of it. So asking whomever's running it, could you please run monthly reports, quarterly reports? How are we doing against the budget? Because ultimately, you are accountable for it if you lead an IP team by the end of the year. And it is no good when you can't meet those expectations.
I know. And changing quickly topics is what we're running out of time. Once you've cleared the mark, you've launched it, you've registered it, you start to develop a good, successful brand. It's time to enforce it. Why is enforcing a brand important?
I mean, for the simple proposition that there are no trademark police. You want to be able to have exclusivity. You want that brand to mean everything in that space to consumers, and that we're the only ones who can get that consumer to our name. I also think if you're in a licensed model, you want your licensees to know that you will enforce it, because that's the incentive for them to be in the system that you're providing, that they can't just go and put a name on a piece of real estate and it will attract customers. So I think it's very important. I think also it's a good barometer to show how successful your brand is. Imitation is a sincere form of flattery. And your CMOs and your chief brand officers, they really want to know that. They want to know the appetite and how the brand is being perceived in the markets, not just with their own data, but it is such a great barometer for folks who really want to make sure that their brand is being protected. For example, if you see in different jurisdictions that you had no intention of going into, that you have a ton of infringements and counterfeits out there, they're going to see, hey, maybe we should be exploring those locations. I've had folks who wanted to convert infringers to operating actual locations in the system, not here, but in a and I said, well, maybe that's not the best approach.
Best idea.
Yeah, but I think that's really how to create a strong brand, to make sure that you are enforcing it, and to alert your CMO and CBO, hey, these are the hot jurisdictions.
And when clients want you to enforce a brand in a country where, say there's lots of infringement, but you don't have use, do you keep, how do you keep track of where you use your mark and for which goods and services? Because this is key to being able to successfully enforce the mark. And do you engage, as some clients do, in an annual sort of review of your portfolio for defensive purposes to see, where are gaps in coverage, or where do we have coverage, but it may be vulnerable to non-use attack?
We do both. We do have someone on the team monitor and collect evidence and use database systems to help collect that evidence and store it. And then we do an annual filing program, assess where we are in the marketplace, and if we need to file for extra protection. So yes, that is critical.
Okay, good. And I think we're running out of time. So just to wrap things up, if you could give us some tips and just best practices on, how to succeed in a global launch and how to fast track a complicated brand launch.
Well, my biggest tip is to have a great time with your clients in doing it. It is really fun to see the joy on everyone's face when a successful brand is launched. And so to always keep them involved, and finally, just to keep track of it all, because it goes by quickly. And then when you can have 200 brand launches, you realize, wow, this was a lot of fun.
Good. Well, I think, thanks, Ainslee, so much. I think we'll open now this up for questions, if I'm not mistaken.
Exactly. I was going to say, Ainslee, Carlos, before we go right into questions, I want to make sure everybody has the CLE code. So write that down now. It's G as in great, the number 6, the number 4, P as in Peter, and Q as in Queen. We do have about 10 minutes for Q&A, so there are some questions in the chat. Feel free to kind of go back and forth amongst yourselves. I know people are really excited to learn more, so thank you so much. I'll pop back in again. But again, that code is G64PQ. Thanks, guys. I'll be back in a few. At the end. So if you do have questions, please try to connect with her, set up a meeting through the system. Thanks again. It was a really wonderful presentation. I know you had a bunch of questions. We'll make sure we try to get to those as much as possible. We definitely love learning so much about international trademarks. Up next, we have our speed networking event starting at 3:30 Eastern. That's actually in a different platform. So navigate with Umbrella to the hyperlink. It will bring you over there. If you don't feel like attending, our next session is at 4:30 p.m. Eastern. We're getting into the weeds, cannabis law and IP protection. Join our networking event and the session by going to the schedule page with Umbrella. There's a hyperlink that will bring you directly there. Thank you for listening. We'll see you soon.
Lauren?
Oh, hi, Ainsley.
Hi, it just totally logged me off.
Booted you out. All right. Well, I mean, people are still around. We do have a couple of minutes. I see there are a bunch of questions there. I know people are happy to do it. I think Carlos dropped off. But if you see a few questions and want to kind of, run through some of them, feel free.
Sure,
We have a couple
sure.
of minutes. So
I'm much more computer savvy. I don't know why it did that. All right. I'm not sure sorry, Lauren, I'm not sure I see a question in the chat.
under the presenters tab.
Oh, sorry.
Yeah, no, took me a second to find it too.
Okay.
Here, I can read out some of them if that's easier. So, what
Great.
tools do you use to clear the mark globally? Also, Madrid Protocol, is that your preferred way of filing or no?
I don't have a preferred way of filing. I still do nationals, absolutely. I think it's just a matter of figuring out within your budget. Sometimes the budget will drive that. So I don't have a preferred. I'm just not skeptical of Madrid. How about that?
Fair. What do you do when the client refuses to change the name, even when you told them clearly that it conflicts or that it's going to be rejected as descriptive?
Well, I think that probably happened when I was outside counsel a little more than in-house. In-house, we tend to know the clients on a more intimate level. And so usually when it's that much of an issue, you would escalate it to others. But sometimes the clients may need to find out for themselves, and understand if you've provided your counsel and advice, sometimes that's the only thing you can do.
Yeah, fair. How do you deal with clients needing to be included on the process? Is there a checklist for 1A and 1B apps that you have or anything like that?
Yes, I will ask them if they've started using, when they're going to start using. I try not to do an ITU unless I have to, just for ultimate cost savings. But sometimes the better rule is just to file an ITU if you have to get out super quickly. But yes, I have a checklist that they have to give me the information before we will file. Everything is pretty much operationalized with that.
Yeah. Oh, cool. All right. A little
Sometimes
preface here.
no.
This may be an obvious question, but do you need to be licensed in an individual country to file there? Is there, were you talking about creating a network of practitioners in different countries, or do you file for yourself in different countries?
So I've done both. I have gone directly to local counsel. I've also, frankly, used Carlos and his firm to file and instruct local counsel directly, depending on how big your in-house team is and how many experts you have. In terms of being licensed in an individual country, I don't think so, but I think you may need certain licenses in order to start using or have the business operate. But to file, no. I mean, if you have a U.S. entity, that generally works as the owner in local jurisdictions in terms of your application filings.
Oh, cool. And then how do you decide when you go through foreign counsel or using Madrid Protocol?
Again, it's what's your staff like? What are your resources on your team? I generally, if I have great paraprofessional experts, I will have them because they'll know more than I would, certainly. And then sometimes half of the people I know, they'd know more. At least that's what they tell me, right? And if it's outside counsel, it's really because I am starting a new position or have a new team and I don't have that expertise yet. Or maybe it's just resources that we don't have the ability to track all the deadlines and we need outside counsel to do that for us.
Oh, yeah, I get that. Changing tax completely. What's your approach to explaining the ROI on trademarking? Just like from a marketing perspective, I think kind of internally for you now, but also, how do you explain that to people? Like, what's their return on investment?
Yeah, so I am very open about how much it costs to file and what the lifespan of that trademark would be. Applications, jurisdictions. I had someone tell me when I started practicing IP, brands are big money. And so I disclose that. I also disclose that they are government fees. And what that may be associated with, and that you can't, there are no coupons for government fees, and it's a non-negotiable. And if this is something that, it may be a project that they don't think may have, it's a nice to have, but not a mandatory for the brand, they may agree with me that it's not something for a global filing program. Maybe it's regional. Maybe we just file in a few places to preserve our rights, but they don't want any additional funds put. And sometimes different organizations have cost control centers. And so you can absolutely raise that with finance and others to say, oh, for you to go farther with this project, they'll have a toll gate system and it's going to be this amount of money.
All right, last one, we'll keep it quick. You had mentioned that 18-month rule. And so someone wants to know if you can explain how that works from a practical standpoint. Recently, they've had notifications from WIPO that the 18-month period had passed, but that the oppositions were still possible. It's not clear what that means. Do you have any info?
So I have to say that this is something that I would rely on the outside counsel for, on the 18-month rule. I know that there are times when, and this is even when you file national applications, deadlines seem to come and then miraculously you still have time to do something. Sometimes it is with each jurisdiction. So this is why I actually think it's critical for someone to monitor all those notifications when they come in. I absolutely would get copied on those notifications, so we would have real-time updates to it. But this is when you really need outside counsel and local counsel to monitor those issues and guide you.
Yeah. All right. Well, Ainslee, thank you again. This is so super helpful. I know that we have all the chat and information there. Everyone who's attending, please reach out to Ainslee if you have other questions, and come join us for speed networking. Again, just go to your schedule page, click on the hyperlink, and it'll bring you right there. Oh, Carlos, back to big party, everybody.
Sorry.
Guys, thanks again. Really appreciate it. Have a great one. We'll see you in speed networking.
Thank you very much.
Thanks.
Enjoy your day.
Thank you.
Bye. Thanks all.